Hey everyone, my name is Vanessa Burgess and I am General Counsel for the Texas Real Estate Commission. I'm going to walk you through some of the topics in today's course book via video. And the first one I'm going to start with is a segment on ad hoc working groups with a specific focus on an ad hoc working group that we had this year. So what is an ad hoc working group? Sometimes the commission will put together groups. It's not an advisory committee like the ones that you've learned about. It's actually a group that's tasked with looking at something a little bit more narrow, more specific. Over the last year, we had one called the Unauthorized Practice of Law Working Group, which unsurprisingly examined the unauthorized practice of law. We also call that group the UPL group. I'll probably switch back and forth in how I refer to them. So the UPL group was tasked with examining issues related to the TREC contract forms and the unauthorized practice of law. So what they did first, and let me go back and just let you know. So this was a group that was made up of commissioners, staff, and then also members of industry. Practitioners, so that we were able to get all of the input needed to really focus on this topic and look at how it's playing out in both the real world and at the agency level in terms of things like enforcement or communications, what we see. I would break their work down into two areas. The first thing that they looked at, this is under Rule 537.11, was making that rule a little bit more clear in terms of the TREC contract forms, when use is mandatory, etc. And they also during that time explored, okay, well, what does this look like? For example, we know that there are associations of contract forms out there. And what are the other possible options on that, and who can draft and who cannot draft language. So they took a look at that, and then they made some changes. They moved on from there to examine the language related to the unauthorized practice of law. And what they did here is they made some pretty significant changes in terms of language with the hope of putting in some clarifying language as to what constitutes the unauthorized practice of law, what does not constitute the unauthorized practice of law. There's a statute that prohibits license holders from practicing law. And there's always the question of, well, what does that mean? And the reality is it's pretty case specific, but there are certainly some rails we can put into place through our rules that show you, okay, this is what the commission means. It's this and it's not that. But again, what is the unauthorized practice of law? The short answer is, does it feel legal? But that's not in nature. Like, what are you talking about? Are you talking about something that implicates the rights of the parties to the contract? Are you simply filling in information? Are you drafting an escalation clause, which you should not be drafting? Things like that. Okay, so before I move on to a discussion about how these changes impact the contract forms, I wanted to highlight two things. One is that the rule language in 537.11 has also been updated to reflect changes in technology, hopefully to move it forward a little bit. We know there's a lot going on with technology everywhere, but in particular in the real estate industry. So cleaned up some of that language. And then, and this is the transition to the contract forms, there is a new rule that's 537.1 that contains a definition of an informational item. And that's important because it ultimately what happened is the UPL group made some recommendations, and one of the recommendations that they made was to the broker lawyer committee for some new language as it relates to special provisions. And that was an interesting one because when you say the word special provisions, this has been my experience, to a real estate license holder, the response is usually, or oh no, I don't want to talk about that, because it's hard, right? That tends to be where this question of unauthorized practice of law would come up. The thought was that the language in special provisions didn't quite wasn't quite clear enough as it related to what a license holder could put in there. And so there's a definition related to informational items. And what the broker lawyer committee did with all of this is they took the recommendation of the UPL group, not verbatim. They actually toyed with it a little bit, and they changed the language in special provisions. But special provisions now includes a reference to informational items, which is a defined term in our rules. And the thought behind that language, and it gives some examples too. So what are you putting in special provisions? You are putting things like if there were names of parties that didn't fit the first blank for that, if there you need descriptions, if you need to talk about multiple counties, things like that. And there's other things we know that it's used for, but those are sort of, when I use those examples, because those seem pretty concrete, right? It's not really changing the rights of the parties in the contract. So BLC made this recommendation based on the work of the UPL group. I say BLC, it's the Broker Lawyer Committee. We'll talk about that in a little bit. But they took that, they drafted some language, and now you have the new special provisions. And why am I talking to you about this? Because one, it's changed the contract forms, and it's a pretty significant one. And like I said, special provisions, there's a lot of feelings about special provisions, and hopefully they are more fond feelings after this change. But importantly, for you as a license holder, the thought behind these changes was to make it more clear about what constitutes the unauthorized practice of law, and to give you a tool to point to as it relates to the unauthorized practice of law and what you can and cannot do. So special provisions specifically references that now, right? It says you are prohibited from practicing law, and that's something that you can use as a tool when your client wants you to put something in there. You can point to that and say, you know what, I can't do that. I can't draft that language because it's prohibited. It's not something I can do. It's a violation of the License Act. And so it's something that's more concrete that you can point to. And I sincerely hope with the rule changes and with the changes in special provisions, that's giving you license holders more clarity, and also language that you can use to point to your clients in the event you find yourself in a situation.